Hi, my name's Katie, and I'm one of the attorneys at the Liker Law Firm. And one of the things that'll come up a lot in the Chapter 13 cases are a motion to dismiss. So what I'm going to do is explain the motion to dismiss, what it is, and what can be done. A motion to dismiss can be a couple of different things. The trustee can make a motion to dismiss for failure to make plan payments, a creditor could make a motion to dismiss for various reasons, or the actual party, the debtor themselves, can make a motion to dismiss the case. What I'm going to focus on are the motions to dismiss by the trustee, and generally those are going to be for non-payment of your plan or on occasion for failure to file tax returns or something like that. So when we're looking at a motion to dismiss for non-payment of a plan, basically the trustee is saying you haven't paid, you should not be allowed to continue in your plan and take advantage of the bankruptcy. There's no hard and fast rule on how far you can be behind prior to the trustee making the motion to dismiss. However, generally, the more you are behind, the more likely a motion to dismiss will be filed in your case. If a motion to dismiss is filed, your attorney will get notice of a response date. If you want to continue in your case, your attorney will need to respond by this date. The response may be a variety of things, most commonly that you plan to become current by a certain date or that you have already in fact become current. If the response is filed, generally you'll have a little bit more time to become current, but your attorney can advise you on the specifics. If you do not become current by the deadline, your case might be dismissed. If a case is dismissed for this reason, you'll have 14 days to become current and reinstate your case. After the 14 days, however, the order is final and you will not be able to reinstate your case, though you may be eligible to refile. It is important that because your payments are made by money order through the mail, that you do allow some time in that 14-day period. If you are paying, only a few days before, you may need to actually appear and make a payment to the trustee prior to the hearing, because there's no other way to make that payment in person to the trustee. It will not be sufficient to say that your payment has been sent. It will need to be received generally. You'll probably want to provide your attorney with proof that that payment has been made in case there are any issues. Your attorney can respond in that way. You may incur costs and additional attorney's fees if you do need to reinstate your case. The best course of action is, of course, to avoid the motion to dismiss whenever possible. You can do this by making timely monthly payments. There's also an option to do a wage order, which is where your employer will direct funds directly out of your paycheck to the trustee each month. This can be divided. For example, if your plan payment is $500 a month and you get paid twice a month, you could have $250 deducted from each check. It would not be necessary to pay only from one check a month. If you have any further questions or would like to speak with an attorney, feel free to contact us today. Thank you.